this, and the session is being recorded also. So my name is Morenike Obifarinde, and I have the great honor to welcome you to this month's ODR Africa Knowledge Sharing Session. And without much ado, I'm going to introduce our speaker. Our speaker is Brian Epps. He's an adult male resident of Augusta, Georgia, graduated from the University of Georgia School of Law, and completed a 2-year clerkship with the U.S. District Judge in Atlanta Division of the Northern District of Georgia. He has practiced law for so many years, where he has represented commercial policy holders in insurance coverage disputes across the U.S. and internationally. And in 2013, Brian became a U.S. magistrate judge in the Southern District of Georgia and has mediated several civil cases in this capacity for the past 11 years. And Brian today has founded Peacemaker, which was founded in 2022, and which is why he's joining us to show us the magnificent app for mediators. We don't usually get so many aids to mediation. So this was a breath of fresh air. We have so many platforms for arbitration, but we don't have too many that can actually assist the mediator. And so that's why we thought this was a very interesting development. So Brian, over to you. Thank you.
Thank you so much. And let me say what an honor it is to be with all of you. I started this company several years back and worked on the technology and released the software last year. So it's been a year and a couple of months since I released it. Through my mediating cases over the last 11 years, I became frustrated with what I call some of the antiquities involved in mediation. We mediate cases now for the most part like we could have in 1920. Of course, we use telephones and Zoom, which we didn't have back then. But the process is still quite, in my opinion, antiquated, and technology is basically absent from it. And so if you look at how you typically mediate a case now, when an offer is presented by the plaintiff's side, then the mediator writes that offer down on a piece of paper, and the plaintiff's team writes it down, and then you go into the other room and you repeat that offer in the defense caucus room, and they all write it down on a legal pad. And by the end of the day, you have a legal pad full of scribbled notes about the first offer made, second offer made, what the midpoint is, what additional terms have been conveyed that are important other than money. And I always look at that at the end of the day and thought, man, that's a sloppy set of notes I have there. And I hope I didn't make a mistake. And I hope my legal pad, where I've written down every offer and counter offer and all the terms, matches everybody else's, that I accurately conveyed these things to other people and that they wrote them down accurately as well. And so that's really the founding thought of Peacemaker was there has to be a better way. There has to be a way for us to digitize that process so that we're exchanging these offers in an electronic way. And there has to be some other ways that we can make mediation easier and more accurate for the parties. Another frustration I had was with risk analysis. I learned risk analysis, probability-based case valuations, when I was a young associate at Kilpatrick, Townsend, and Stockton. And it's simple in a lot of ways, but the math is not easy. And so for those who have never heard of risk analysis before or risk assessment, it's basically a way for you to take your gut instinct about what a case is worth and translate that into a defensible valuation of the case, where anyone with a PhD and economist would sit down beside you and say, yeah, the way you evaluated that is consistent with strong valuation principles that have been used to value businesses for a very long time, because a lawsuit is an enterprise, an attempt to make money on one side and to on the other side reduce the amount of money that you have to pay. And so it's very much like a business where you've got lots of potential outcomes in the future, and you're trying to place a present day value on the company based on what you think might happen in the future. And so, but the math is not easy. And lawyers get confused when they do, and mediators too, when they prepare their own risk analysis. And so I wanted to make that simple. I wanted to do the calculations for you to make risk analysis something that more people would consider using in the course of mediation, because I think it's important for, and I'll show you why in just a minute. So those were the two initial thoughts as to where I could make a difference in the world of mediation. Another way is when you get to the end of the day and you have an agreement, it's not easy, even in today's world, to take that and put it in a form that you can sign the same day. And I think that's important, to walk away from a mediation with a signed agreement. It may just be a placeholder agreement that just covers the basic terms, and so that you can later on prepare a more fulsome release of liability. But I think it's important to seal the deal at the mediation when you've reached an agreement. But everybody's tired, and a lot of times there's not an easy way to do that. So I wanted to fix that problem as well. And I also wanted to give mediators some feedback about their performance. You know, when you take an Uber or a Lyft ride in a city these days, when you get out of the car, the first thing the Uber asks you to do is to rate the driver. How did the driver do? And you give instant feedback about the driver's performance. Well, mediators don't get instant feedback. And so I wanted mediators to be able to get that as well. And so I'm going to show you the result of all that effort that I engaged in, which is Peacemaker, which you can, if you want to know more, you can go to peacemaker.legal is the website where you can see more of it if you're interested after today. Or obviously you could also email me or even call me, and I'd be glad to talk with you one-on-one about this if you're interested. But I want to share my screen now. Let's see. All right. Okay. So what we're going to do is start off by just showing you the inbox. When you first log into Peacemaker, you're going to see all of your cases, ones that have settled, ones that are ongoing, ones that are in the future. You create a case very easily, but by just typing in the case name and the case number, either your number or the court number for the case, and then a general case type, contract, consumer rights, divorce, insurance coverage, whatever it is. And then you choose whether you want the parties, whether you're going to require the parties to prepare a risk analysis and share it with you, or whether that's an optional thing for them to do. Then you choose the date of the mediation and the time, and that's how you create a case. And then you have a team builder function where I'm going to go in here and just type in the name of one attorney on the plaintiff side that I know. All I'm going to do is put in their first and last name and their email address. And whether they're an attorney or a client. And, you know, if I have two or three attorneys on one side of the case, I'll typically just type them all and put them in here. But you don't have to. You can just type in one attorney's name. And when you add them to the case, it automatically sends them an email. And the email says, Brian Epps is the mediator for Smith versus Smith, and he will be using a product, a software package called Peacemaker, in addition to any Zoom or Teams technology that might be used for video conferencing. And so you need to log in, create your account, which is free to the attorneys. Only the mediator pays for the Peacemaker account. Create your account, and the case will be waiting for you when you get there, Smith versus Smith. And the mediator has either required that you prepare a risk analysis and share it with him, or you may do so. It's either optional or required based on what the mediator says. Now, when the plaintiff's attorney receives that email, it also says if you want to add other people to your team, you can do that as well. How do they add them? The same way we're adding attorneys here, just first name, last name, email address, and whether they're attorney or a client. And so in that way, you can have one attorney that you invite in a cascading registration process, maybe add 3 people that he thinks needs to be part of the case. The paralegal who's working on the case, the client, maybe the client's a company, and so the CEO wants to be part of it, the CFO, and the risk manager. So you add those people to it. Well, then it invites those people to join as well. And it encourages them to think about other people inside of the company and the law firm who might also want to participate. And it's not just people who are going to be in the mediation that day. It can be anyone inside the law firm or the client's office that is interested enough to follow developments as they occur through the day, even if they're not participating. So that if the CEO is in Los Angeles while the mediation is going on in New York, he or she can receive a text message every time an offer is made in the case and log in and see what's going on in the case, which I think is a very helpful aspect of it. So we've added all the people we want to add on the plaintiff's side. So now we're going to go to the defense side and do the same thing. Just add one, and it'll do the same thing, invite them to register. Now, I'm going to show you a case that we've already gone through that process, and we're at the day of mediation. On the day of mediation, you can go into your inbox and then select the case. And you can see that the plaintiff's team has 2 members. And the green dot means that each of these people received their invitation and logged into Peacemaker and created their account, their free account. And then on the defense side, we've had 1 person do that as well. If you want them to share case documents with you through Peacemaker, they can do that. I created this aspect of it because I think that when people email you mediation statements and exhibits, that number one, it's a large size exhibit file. It can be difficult for you to receive it. But number 2, it is much more secure for them to log into Peacemaker and upload their mediation statement and their exhibits than it is for them to email it to you. It's just much safer to do encrypted uploads than it is for them to email you something. Now, the defense has not completed a risk analysis or shared it with me, but the plaintiff's team has. So in advance of the mediation, I've received this from the plaintiff's team, and it is a risk-based valuation of their case. How did they create this? Well, we're going to go now. Right now, you're looking at the mediator perspective. This is the mediator login, the mediator's account. Now we're going to go to the plaintiff's attorney's perspective and see how they see things. And what I'm going to show you is the risk analysis that they prepared. What's the probability of the court dismissing the entire case before trial by granting a motion to dismiss or motion for summary judgment? And what is the estimated total of fees and costs your client will incur in the future for such a motion? Not in the past, but in the future. Well, the plaintiff's lawyer said there's a 20% chance of me losing before I get to trial because the court dismisses the case, and that I'm going to spend about $100,000 in US dollars to get through that stage of the case because it's a complicated case. Okay, at trial, what is the probability? So in the 80% of the time when it's not dismissed before trial and you actually go to trial, what is the probability of a complete defense win? And in contrast, the probability of the plaintiff recovering on at least 1 claim. So they say at trial, there's a 40% chance of the defense winning and a 60% chance of the plaintiff winning. All right. Now, let's focus on when the plaintiff wins. When the plaintiff wins at trial, what's the probability? What's your highest award amount? The medium award amount you would expect to receive, and then the low amount. If you had your worst day at trial, what's the low amount that a jury might offer? And then give us the percentage chance of each of those things occurring. And so this plaintiff says, look, if we can get past some of our hurdles on liability and actually get something, an award from a jury, we think there's a really strong chance here we're going to get a lot of money. We have a 60% chance of getting $10 million. But there are some weaknesses in that argument. So we recognize there's a 30% chance that we only get 7.5 and a 10% chance that we could really have a bad day and get 5 million. And so the next question is, okay, for the $10 million award only, itemize that for us. Show us how you get $10 million. What is that made up of? And the answer is, well, 4 million of that is lost profits, no medical expenses because it's not that kind of case, 3 million in property damages, 0 in liquidated damages, 0 in pain and suffering, 225,000 we think we can receive in attorney's fees, 0 in statutory penalties, and $3 million in punitive damages. And that is how we think we can get a jury to give us $10 million. And so, and the last question, what's the estimated total of future fees and costs your client will incur through trial and final judgment? $250,000. Okay, with all that being said, what is the risk-weighted value of your case? Well, there's a 20% chance of it being dismissed before trial. There's a 32% chance, and the Peacemaker does all this math for you, 32% chance of a defense trial win where the plaintiff doesn't recover anything, a 28.8% chance of a $10 million verdict, 14% chance of a $7.5 million verdict, and a 4.8% chance of a $5 million verdict. So what does that mean? It means that if there's a 20% chance that you're going to not get anything because it's dismissed before trial and you spend $100,000 to get through that part of your case, there's a 20% chance you're going to lose $100,000. And so that particular outcome has a negative value here of $20,000. It decreases the case value by $20,000. At trial, there's a 32% chance that the jury's not going to give the plaintiff any money, and the plaintiff will have spent $250,000 to get to that phase of the case through trial. And so there's a 32% chance of losing $250,000. So there's a negative value there too of $80,000 because there's a 32% chance you're going to lose $250,000. But on the bright side, there is a 28.8% chance of getting $10 million. You're going to have to spend $250,000 to get that outcome through trial. So your net recovery is $9.75 million. That particular outcome is then worth $2.8 million. The medium award, you see the same thing, and the value of that's $1 million. The low award, the value of that's $228,000, and the total suggested case value is $3.98 million. So I received this in most of the mediations that I prepare. Most of the time, the lawyers not only prepare it, but they share it with me in advance of the mediation, along with the mediation statement that's 10 pages long and tells me about the facts of the case and attaches exhibits. And I find often that the information conveyed through this risk analysis is just as important to me as the information that I receive in the case statement itself. I had a case not too long ago where it was an employment discrimination case, and the plaintiff in their mediation statement certainly conveyed to me this sense that the case had some problems and they might not be able to prevail if they couldn't get the case settled. But much to my shock, when I opened up their risk assessment here, they had placed the chance of them losing the case prior to trial by it being dismissed at 70%. And so then I went to the defense risk analysis, and it said there was an 80% chance of the case being dismissed prior to trial. And so walking into that mediation, that one number on this page informed a lot of how I handled the mediation. I didn't have to go into that mediation to convince the plaintiff's lawyer that they needed to settle because the case was weak. I didn't have to waste one single breath on that. And later in the day, when I started to get some resistance to settling the case, I knew immediately it was not the lawyer. The lawyer knew they had to walk out of there with a settlement. It was the client that had the problem because the client didn't understand that huge risk of losing. In other cases, this information can help me in other ways. I mean, first of all, the case value itself, it's a starting point. It's not the end point. And because of advocacy bias, it's always fascinating to pull these up and look to see what you have on both sides. Typically, because of advocacy bias, the plaintiff's valuation of the case is higher than the defense valuation. Because the defense thinks they have a better chance of winning, and the defense thinks the case isn't worth nearly as much, and then the jury is not going to even consider $10 million. That's ridiculous. You know, the worst we can get at trial is $6 million. Might be a good example of that. But when the plaintiff's team tells me that the high award, if they get everything they want, is $10 million, and the defense team says it's $6 million, I circle those things because I want to talk to them about that through the day and find out who's right and who's wrong and why. If at the end of the day, their case valuations are what I expect, where the plaintiff's valuation is higher than the defense valuation, I might say that to them at some point. I might say to the plaintiff's team, look, you value your case at $4 million. Do you think the defense agrees with that? Of course they don't. I can't tell you what their valuation is, but it's significantly lower than yours. Why is that? Where is the truth? The truth is probably not 4 million. And it's not their significantly lower number. The truth is probably somewhere in between those numbers, you know, as a way of getting them to think differently about their case and to try to move in the direction of the other side. Sometimes, in maybe 20% of the cases, the valuations are shockingly close to one another. In another 20% or maybe 15% of occasions, the numbers actually cross, where the plaintiff's valuation of the case is lower than the defense valuation. A lot of times that happens because of how the risk analysis is conducted. On the plaintiff's side, if the plaintiff says there's $250,000 that they'll have to incur in expenses to get through trial, then and a $10 million award at trial, then risk analysis is going to deduct the 250 from the 10 million. Why? Because what you really want the plaintiff focused on is their net recovery, right? How much they're going to put in their pocket and their client's pocket after they incur all of their expenses. Well, on the defense side, it's a little different than that. On the defense side, we're going to take the 250 and add it to the 10 million because we want the defense focused on their total loss at trial. So a lot of times, just by simply making them do the risk analysis, you can bridge the gap some because you're reducing the plaintiff's valuation by how much it costs them to try the case, but you're adding that defense cost to the defense side valuation of the case because that's what their total loss will be. So you get the other thing I do is I look at their itemization of damages. Sometimes there can be a difference in opinion on something that there should not be any difference. Like in an employment case, I'll get this and it'll say on the plaintiff side that they're seeking at trial 25,000 in lost wages. And then I get the defense statement and it might say that the plaintiff is seeking 45,000 in lost wages. Well, somebody's wrong. Somebody's got the numbers wrong. And so I talk about that. Look, y'all disagree about this number, or maybe it's the medical expenses. That happens in a lot of personal injury cases. You'll get a slip and fall case where the plaintiff says we have $100,000 in chiropractic bills or ER visits, et cetera. Total expenses, medical expenses are $100,000. Well, in America, that medical expense number in a personal injury case is very important. It's the driver of the overall value of the case. And so a lot of times, the medical expense number that I get from the defense is somewhat different than the number that I get from the plaintiff. And so I have to talk to them about that. Typically in the opening session, I'll say, look, there's a difference here. Why? Y'all should at least be able to look at all the medical bills and add them up and agree on what that number is so that we're operating on the same foundation for what the case is worth, right? You might disagree on how strong or weak liability is, but at least we can agree on what the medical expense number is. So that's been very interesting. And the last thing I get is the actual question and answers that they they went through. Now, you don't get the risk analysis from the parties every single time. Sometimes they're just not going to give it to you. And that's okay too. But what I'm maybe more interested in is that they've actually done this themselves, taken their gut instinct about what they think the case is worth and turning it into a defensible, real valuation so that you get them to start thinking about case valuation, not as just a broad, big wall that they can just throw their dart on, but instead a dart board where we can say, look, let's just bring this valuation in and make it a more disciplined experience for you. And the percentages can really get interesting because lawyers just bad with numbers and they don't understand percentages. And I always use this example. If you have a general go to a president of a country and say, look, we've got to invade, invade another country. And I know you wanted me to assess the chances of us succeeding. And I think there's a 70% chance we'll win this war. And then the president says back, well, 70% chance of what? What's the percentage chance that you can actually establish a beachhead, like in Normandy during World War II, where you actually can land our troops safely and establish a safe beachhead from which we can launch our drive to the capital of that country? Well, there's a 70% chance that we can do that. I've already told you, 7% chance we'll win. Well, but that's only first stage, right? That's stage one of the war. We have to establish a beachhead. After that, we've got to launch an offensive that takes us through the countryside and to the capital where we take control of the government. What is the percentage chance that we can accomplish stage two? 70%. Well, guess what? That means there is a 49% chance of you winning this war because 70% chance of one is not equal to 70% chance of the other and 70% chance of them winning the war. The way you calculate that is 70% times 70%. There's a 49% chance of you winning the war. And that's what Peacemaker does for you. It calculates the percentages within the percentages so that you can have, without you having to worry about the math, there's a 14.4% chance of getting the medium award amount of 7.5 million. So it does the math for the attorney. And the last thing it does, if the attorney uses it the right way, it gives them a way to approach their client and have an honest, accurate conversation about the risk of moving forward. And if they've done that in advance, then they walk in, I think, with a better mindset. I use risk analysis in the mediation sometimes. It doesn't come up a lot of times. I just have a piece that they've done it, and it shows me valuable information about the case before I walk in. One time I use it, though, a fair amount is near the end of the day, especially in the plaintiff's room when they have an offer that I really think they need to take. And so let's just say in this case, we had an offer of $8 million on the table. And the plaintiff, the client, is having a difficult time deciding what to do. Well, I might walk in there and say, look, your attorney said there's a 20% chance that you're going to lose before you even get to trial, and a 32% chance that you're going to lose at trial. So overall, there's a 52% chance here that you are going to lose and not get $1. In addition to that, at trial, there is a 4.8% chance that you're going to get only $5 million and a 14.4% chance you'll only get 7.5. And so at the end of the day, there's only about a 28% chance you can do better than this if you move forward with your case. So take the 8 million. Take the 8 million because there's a 72% chance that that's your best day, right? And to me, it is super compelling. But you got to be careful because sometimes even when the plaintiff's attorney shares the risk analysis with you, they haven't shared it with your client. And if they have not, you have to get permission from them to talk in those kinds of terms. Because a lot of times if you don't get permission, the client's blindsided and they can lose a little confidence in their attorneys. They can say, well, you didn't tell me this. Why do you think there's a 52% chance we're going to lose and not get a dime? And clients can get very upset. So you have to be careful how you approach that, and you have to make sure that the client is aware of this before you bring it up and talk about it with them. I've made that mistake, and I don't want you to make the mistake. Does anybody have any questions about the risk analysis component of this, or the team builder component that we went through as well? Okay. No questions. Let's move on to the day of the mediation. So by now,
I had a question. If
sure.
you talk about the risk analysis, this is just amazing. My question to you is, how does that work? Did you feed the system with a lot of data that makes the analysis possible, automatically possible?
No, all of this is derived from the questions and answers that we just reviewed here. So in brief, I'll show you how it works. If the attorney says there's a 20% chance of it never even getting to trial, right? Then that means there's an 80% chance it's going to go to trial, right? Well, if there's an 80% chance it's going to go to trial, and then a 40% chance that at trial the defense is going to win, that means there is a 32% chance overall of a defense verdict. Why? Because 80% times 40% equals 32%, right?
Yeah, so it's on the basis actually of the questions you have established and to which they brought answers. Okay, thank you.
Right. It is a straightforward calculation of the percentages based on the information the attorney has put in the system.
Yeah, it looks very intuitive so far. I'm curious to see the rest. Thank you.
Okay. Anybody else have any questions about the risk analysis before we move on?
Mirez, just to add to what you said,
Yeah.
Further. So the idea of the risk analysis is really just, as Brian had said, to prepare the parties so that they understand what it is that they're facing at the mediation. That's why I said it's such a helpful tool, because you then don't have mediation advocates come in and just come and grandstand and waste everybody's time, because they already know, and the clients already know what the weaknesses or the strengths of their cases are, and they're just ready to discuss using the interest they've established to get what they want, or to give what they know that they definitely would never be able to get. So it's such an interesting.
Yeah, it's just excellent so far. Thank you.
Well, I'll tell you that this is not new. There's a Harvard Business Review article from the 1950s that I think is one of the first educational pieces about risk analysis, but it's not even talking about it in the context of litigation. It's talking about it in the context of a business that is has a lot of potential opportunity in the future, but a lot of risk as well, right? And so it says, what do you do with a company that you're about to invest $1 million into that could ultimately yield a profit of $100 million or go bust and go bankrupt? And so it says, well, you have to assign probability to all those things and come up with a present day value of the company based on the percentage chance of all those outcomes occurring. And it's become the backbone of business valuations. And litigation, I think it started to take hold in there pretty soon after that as well. And if anybody wants that Harvard Business Review article or some other articles that I've written or I've read that other people have written, I'm certainly glad to share those with y'all as well.
That would be great. If you send it to us, we'll just share to all those who signed up for this.
Okay, I'll do that. And I'll err on the side of sending it from other people, because I've already kind of shared with you my thoughts on it. All right, so all this is done before the day of the mediation. On the day of mediation, I do not mention Peacemaker until I've already had the joint opening session with the parties, and we go into our first caucus session is when I bring it up. And I want you to understand a couple of things about it before we look at it. Number one, it does not matter if the mediation is completely in person or if it's completely online where everybody's on Zoom or Teams, or if it's a hybrid mediation where some people are in person and some people are online. This ties everybody together in one platform. You can log in on your laptop, your tablet, or your phone. As mediator, I typically use my phone to run Peacemaker. even if I have a Zoom session up, I usually use Peacemaker to run the session. And you'll see why as we go through it. The mediator only has two buttons to choose from, deliver or return. That's it. That's all you do all day long is deliver the offer or return it to the party who made it. So I like to use it on my phone for that reason. The other thing is the timing and sequence of it. You know, it's a tool to use that is completely up to you and your style of conducting the mediation. I'm going to tell you how I use it in my mediations, but yours could be very different. It can be used in a mediation where everybody is going to report on the same day and to have a synchronous mediation where everybody's involved and participating on the same day. It can be asynchronous mediations where maybe you talk with the plaintiff on Monday and they give you an offer, and then you're going to talk with the other side on Wednesday of the same week. It can be used in any of those contexts. The timing of how you exchange the offer is completely up to the mediator. The last thing I'll say is I don't mention Peacemaker until I get in the first caucus session. And in that caucus session, I do it the same way I always have done it. I listen, I ask questions, I give them some thoughts to think about, and then I usually leave the room and say, look, I want y'all to work on what you think your first offer ought to be. But instead of you calling me back here into the room to tell me what the offer is, and I write it down on legal pad, you write it down on legal pad, I want you to send it to me through Peacemaker. When you send it to me through Peacemaker, it's going to bump my phone and tell me that it's there by text message. I'll know that you're ready for me, and I'll come back in the room and talk with you again. And so we're going to do what I refer to as parachute into a mediation that's ongoing, and I'll show you what we've done. So you hit the join session button, and when you do that, it's going to show you, first of all, what's happened so far in the case. So far, the plaintiff made an offer of $9.3 million with two important terms: a 10-year warranty on all defective parts and flat pricing on existing parts for 5 years. The defense came back at $1.5 million. It deleted the warranty term because it doesn't want to give a warranty, and it changed the flat pricing from 5 years to 3 years. And so you can see those written terms by just clicking on the offer. When you don't expand it, it gives you a nice little summary of the dollars so far. And it shows you that the midpoint between the first two offers is 5.4 million that's the midpoint between 9.3 and 1.5. Well, then plaintiff came back and made a second offer of 9 million. So moved from 9.3 to 9. And that reset the midpoint at 5.25 million. And so the plaintiff has decreased their first offer by 3%, and the midpoint has now been decreased as a result by 3%. The defense came back with a bracket offer and said, you know, if we will put up 4 million on the table, if the plaintiff will come down a lot from 9.3 to 6.5. And that's going to establish a midpoint in the case of 5.25. We like that midpoint, so we're giving you this bracket to consider. And so the plaintiff has now come back with a bracket offer itself of 8.25 million and 6 million. And the plaintiff has sent this offer to the mediator. And so the mediator only has two buttons to choose from. I'm either going to return this to the plaintiff's team because I'm not sure that a bracket offer is really going to help us any right now. I'm going to talk to them about doing something else. Or I like it. I think this is what we ought to do. I'm going to send this to the defense team. At this point, the only people who know about this offer by the plaintiff is the plaintiff's team and the mediator. The defense does not know that this offer has been made. And if the mediator sends this back to the plaintiff, the defense will never know that it was suggested. So the mediator is just going to send this over. And I told you I use my phone for this, and I'll show you how. We designed this so that it stacks very nicely. See how that stacks? So that If you're using a laptop, it shows you everything side by side. But if you're using a tablet, it's going to shrink it a little bit and make it on top of each other, stacking it. And if you use a cell phone, it's going to stack it even more, so that you can scroll down and see these things if you want to. And so that's what I do. I use my cell phone uh, to send the offers back and forth. So I'm going to deliver this to the defense now. Are you sure you want to do that? Yes. And so now I'm going to show you the defense perspective. It adds it to the offer history, the offer that has been delivered. And then we go to the defense side. So this status bar up here shows everybody what's going on. The mediator has now delivered it to the defendant, and so it's the defendant's turn to do something. And so the defendant can make a conventional offer or a bracket offer. The defendant can attach anything they want to attach. There may be some photograph that's really important to the case that the plaintiff hasn't seen yet, so they can attach that. Or there may be a really complicated set of terms, 3 pages worth of conditions and terms they want to send across. They can do that. Here we're just going to say, you know what, you offered to sell for 7, your bracket said 7 million. We want to get the case settled, and that number is fine with us. So we're just going to counter at $7 million, and we're going to take this full flat pricing on existing parts for 3 years. We're going to change it. We're going to say we're going to go back off, and we're going to be generous and say 7 years, and we're going to save that change. And then you hit send counter offer. Are you sure you want to do that? Yes. So the mediator receives that only. The mediator looks at it and decides, yeah, I'm not going to return that to defense. I'm going to send that to the plaintiff because I think it's a good outcome. And so the plaintiff gets it. Hold on, I'll get back in the session. Plaintiff gets it and says, you know what, 7 million with that term, I'm fine with that. They gave me 7 years on flat pricing. That's good. I'm going to accept it. So you hit the green button at the top, accept offer. Are you sure you want to accept this offer? Yes. When you do that, everybody, the mediator and all the parties immediately get confirmation that it's settled. And then the parties have an option of looking at a term sheet. The term sheet automatically brings in the case name, the case number, the amount it's settled for, the extra term that they agreed to, the special term of flat pricing for 7 years, and then gives you blanks to fill in. You know, who do we make the check out to? Who's it to and who's it from? Are there any third-party liens in the case? And if so, who's the lien holder and how much has to be paid? And if there aren't any lien holders and you don't want any mention of it, you just delete that from the term sheet. Are you going to admit liability? No. Are you releasing everybody? Is this a global release or just a unilateral release of just the defendant? It's a global release. What kind of release of claims? Is it all claims of any kind, or is it just the claims that are similar or exact to the ones that were asserted in the case? All claims, complete peace among the parties. It's confidential. Nothing can be said publicly. We can share it with our attorneys and no one else, so on and so forth. And then at the end, this agreement contains all the essential terms and is binding immediately, or it's not binding immediately, and it's contingent upon execution of a formal settlement agreement. Of course, you can take that out too if you want. It's fully modifiable. And once you get a final settlement agreement, we don't have a DocuSign capability here, but you can save it to your desktop, and then share it with other people by email or any other way that you share documents from your computer, so that you can get it signed same day, and everybody has a binding settlement agreement then. All right, after you do that, the last thing you can do is give the mediator some feedback, because Uber drivers get feedback, but mediators don't. You know, please leave a rating. This is confidential rating information. No one else gets it but you. Please leave a rating for your mediator out of 5 thumbs up. How did they do? On a scale of 1 to 10, how likely are you to recommend Brian to a friend or colleague? Extremely likely. And then if Brian did a good job today, leave him some comments so that he can put it in his marketing materials. And then you leave the feedback. You don't have to answer all this. You can X out of it without leaving any feedback like this. But I think it's important to have that feature in there. The last thing I'll tell you before I turn it over to y'all for questioning, and I really appreciate your time, it's been such an honor, is that there's an enterprise version of this too. So that if you have a mediation firm or association, it can track a lot of information for you. It can tell you how many mediations occurred yesterday, the type of mediations that occurred, the success rate of those mediations, the success rate of each individual mediator, the case types that each mediator is currently mediating. Like, 20% of my cases are consumer cases, 80% of them are something else. A lot of compelling statistical information can be pulled from this in an enterprise version of it. And that completes my presentation. And I'm opening the floor for any comments or suggestions or questions.
Thank you so, so much, Brian. We have a couple questions. Are parties given access to each other's risk analysis, or is it shared only with the mediator? Well, there are a couple. I'm just going to run through them and then maybe you can, but they're on the chat anyway. Or
let me ask you. I'll answer. Is it okay if I answer that one before I?
Okay, great.
Okay.
Great.
All right. So I'm going to show you the plaintiff's attorney view of the case. And we're going to go down. There's actually something else I forgot to show y'all, but let's go back and look at their risk analysis that they performed. All right. So when they performed their risk analysis and they looked at their table, you see the sharing options button here? It only allows you to share it with members of your own team and with the media.
Okay.
So this attorney, the client is Amy Epps, that's my wife, and the mediator is Brian Epps, right? So you can only share it with people on your team and not with the other side. I did not want any accidental information to be shared. The other thing I'll show you quickly that I forgot to show you is the chat rooms. There's a chat room for you to talk with the plaintiff side. There's a chat room for you to talk with the defense side, but you cannot talk with both of them in the same chat room. Only one.
So each side is actually like in a private room, as it were, on the Peacemaker app. Each party, each side is on their, each team is secluded from the other.
Right.
Great.
Absolutely. All right. What would
It's also possible to share the information with the other party, though you could share by email if you wanted to.
True. Right. Exactly.
Okay. And then I have, sorry, Mirez, I'll come back to you. I have a few more questions on the chat box. Additionally, how reliable is the risk analysis, given that attorneys may sometimes present an overly optimistic or pessimistic outlook? That's interesting.
Yeah, so that's part of it, right? I mean, certainly it is based on the subjective viewpoint of the attorney, right? And so if an attorney is being overly optimistic about their chances, typically I'm able to spot that, right? Because if they tell me there's only a 20% chance of them losing at summary judgment, and the defense tells me in their risk analysis there's an 80% chance that they're going to win at summary judgment, I circle those things because someone's probably not being honest with themselves or with me. And as I go through the day, I want to learn more about that, right? And sometimes, as we know, we learn that the plaintiff just kind of has their head in the sand and that there really is a greater than 50% chance the case will never even get to trial. And so if I realize that, then I understand, because of that risk analysis, I understand where the problem is. Part of the problem is they don't understand the likelihood of it being dismissed before they even get to a jury. Hello? Y'all there?
Yeah, I'm here. Sorry, I think it's my internet.
No, that's
Can you
fine.
hear me now? So is Peacemaker web-based? So mediators outside the US will also be able to receive SMS?
That's a good question. I've not, so I'll say this, you not only get You get a text message anytime something happens during the mediation session. When an offer is made, it sends you a text to say, hey, new offer has been made. Log in the Peacemaker to see what's happening. But it also sends you an email. So even if the text message does not work internationally, which I don't know the answer, it will send you an email that gives you the same information.
So you still get the notification. And then the last question on the chat, well, I think I have one more. Can Peacemaker be used for non-monetary mediations?
Yes. So in non-monetary mediations, the best use of Peacemaker, if you exchange the offers through Peacemaker, it number one, it does a much better job than email because you don't have to worry when they send you the email, did they include everybody on their team that needs to know what offer has been made? And then when I go to forward the offer to the other side, in email, I always have to worry, did I remember to type everybody's name in there to send it to the right people? And did I include too many people or did I include someone on mistake? Peacemaker takes all that out of the equation, right? Because you've got the teams already built in there. And when you share the offer across, it's only going to be shared with the team on the other side, and it'll include everybody that should receive it. And it also stacks those chronologically, right? So that if you want to know, oh, what was that offer the plaintiff made yesterday, that where they had that 5-page term sheet, you can go back very quickly and find it because it's all stacked inside the offer history instead of having to go back to your sent items and your deleted items to try to find an email. So it does serve a very important purpose in non-monetary cases. The next question was, at what time do the parties come together to conclude the mediation? I want y'all to understand this does not change how you mediate cases. It is a tool to replace the legal pad during negotiations. So you conduct your mediations how you always do. If they're in person, you're just using Peacemaker as a way to convey the terms back and forth. You're still going to meet with them in person. You're going to still have an opening session, still have a caucus session. All of those things will occur the same way that you always prefer those things to happen.
Mirez, you have the floor now. Thank you. I have two small questions. First, with respect to the agreement, which I find excellent because it's automatically generated. Is there any deadline that is either proposed or requested from the parties in terms of deadline for the payment? Because what happens if, for instance, they agreed, which we saw oftentimes in mediation, at least I saw cases at the ICC, but then the parties drag their feet for the payment. So is there any agreement in terms of deadline?
I didn't go through it, but there's a schedule that we propose in there of, okay, if you're gonna give if you need to prepare a lengthy settlement agreement, who's going to prepare it? When are they going to submit it to the other side? How long does the other side have to review it and get back with comments? After you finalize that agreement, how long before execution occurs by both parties? And then when is the check? How are you going to pay, and when is that payment going to be issued?
Okay, because I didn't see it in the agreement. So is that also in the agreement that you showed us?
Right.
Great. Great. And another question regarding the additional people that may follow the case. It's probably, I mean, for instance, I'm the CEO of the plaintiff, and I'd like to know what's going on. Do I ask the party to let you know that I would be interested in following up the process? How does it go? Is the other party, the respondent, notified of the fact that I am going to be able to follow the procedure?
No. So the mediator can see your entire team that you invited to participate. But the other side cannot. So if your CEO wants to follow, your client's CEO wants to follow the negotiations, the mediator will know that, but the other side will not.
Interesting.
I thought that was sensitive information. If the case is one that's gotten the CEO's attention, that fact alone might be very sensitive information that because it could suggest they're going to pay you more money in the end, right?
That's right.
Because it's
Yeah.
a case that's really bothering the top leadership. So I didn't want those teams to be available to the other side. So the CEO can follow the entire day without anybody knowing that they're doing that.
I see. I agree. I didn't think about that. Thank you.
Thank you very much, Brian. Thanks, Mires. Do we have any other questions? Else, I'm just gonna turn this over to Mires. Mires is chairperson of ODR Africa Network. I'm just gonna ask her to please say a big thank you to Brian. This has been a very enlightening and educating session. I have thoroughly, this is the second time I'm attending this, and every time I learn something new about the Peacemaker. So thank you very much. I'm gonna ask Mires to do the honors. Mires, over to you.
Yes, not only a thank you, but this is just amazing because it's really very user-friendly, intuitive from all the platforms that I have seen so far. I think really this is the most accessible to parties and easy to use. And of course, when you speak about using tools online for the parties, they're always resisting because they think that it's going to be complicated, but this is really intuitive and so helpful. So thank you very much. I discovered something completely new. I didn't follow you when you presented at iCoder, but now I'm very happy that Morenica invited you because I would have missed this totally. And this has been really very, very useful. Thank you so much.
Well, I'm a peacemaker and I love peacemakers. And it's an honor for me to get together with all of you. And if y'all have any follow-up questions, or if you're interested but you're not quite there yet and you want to do a demo session with me where you run the session and I watch you and help you learn more, I'm available. All you have to do is just email me at brian@peacemaker.legal, BRIAN @peacemaker.legal, and I'll be glad to set something up with any of you individually.
Thank
Thank
you.
you so much for the offer, Brian. And we'll definitely be in touch.
Okay. Thank you so
At this
much.
point, we just want to say thank you to everyone who has taken time out to join us. We have some people, because as I said, we're streaming online. And so we have some people joining us online. To everyone, thank you very much for your time, and do have a lovely morning, afternoon, evening, wherever in the world that you are. Thanks. Bye.
Bye.
Bye.